I was looking at the convictions of DMA, the conviction of Lana Patrick. And again, I don't know these persons at all, but there was something here that struck me. You know, we always hear about the First Amendment auditors talking about the rights of the First Amendment. What I'm trying to say is that constitutional rights are not unrestricted. There is always a limit, because if a First Amendment right was unlimited, then it would mean that every other right around it has to give way. What we actually see is kind of a balancing test. Now, the issue here for auditors is when they go to DMV offices, Social Security offices, welfare offices, unemployment offices, and they walk in and they start recording. What I hear them commonly say is, it's a government building, I'm in a public space, I have a right to record. That won't get you very far. So let me show you, because I want to make this a quick video and I can't cover everything. Let's take a look at just a little table that I've created here. So DMA was a federal case, convicted on 2 counts, failure to comply with prohibitory signs. How many times have you heard an auditor say it's just a sign? Actually, that sign could be a recitation of the applicable law, such as the Code of Federal Regulations, which it usually always is. And then count 2, prohibited photography. In the U.S., the United States brief, they wrote, quote, that photography will, quote, chill both government employees and the public from exchanging confidential information, slow down agency operations and be distracted by live streamers. So here is the argument put out by the prosecution that there is a right of privacy here, which makes sense, because there are areas that the CFR allows you to record without any problem at all, foyers, entries to buildings and things. And then Lana Patrick, they really threw the book at her. This is Alabama now, that there is no unfettered right to just simply record wherever you want. And for Lana Patrick, for her problem, the courthouse and the revenue office were all in the same building. And the commissioner of the revenue came out and said, you know, basically you can't do this. There were a deputy sheriff called, and, you know, I think he warned her 3 times, and she got severe sentences. And you can tell from the language that Alabama was saying, they're not from here. The comments, and I have all this stuff, was, let's make sure they never come back to Alabama again. So there was the signal that was being sent. Count 1, convicted, 10 days to serve out of 30. Count 2, 30 days out of 90. Count 3, 140 over 365. Now, Chile got himself a radically harsh sentence at 180 days. This is 180 days, but it's all consecutive, like Chile's, and 485 days total, 6 years probation. They were sending a message. The judge wrote in his conviction of her, moreover, sensitive and protected information is processed and maintained throughout, and those same taxpayers that expect expediency and expect privacy. It is also inconsistent with every holding this court has found to allow unfettered picture taking and video recording within offices that handle such material. He was convicted on 1 count. It was only a $120 fine until he said he wanted to appeal it. Then the judge raised it to $500 and no jail. The judge deemed the Social Security office where he filmed a non-public forum. And the reason this is important is a non-public forum has less restrictions on it, and the restrictions usually just have to be reasonable for constitutional tests. Then George Metz, this one is pending right now. I've read the briefing. The prosecution talked about sensitive personal information. And then the government argued that it's a non-public forum, and I think they win on that argument. Then they quoted to a case that government agencies are charged by law with doing particular tasks and take actions to help do those tasks as effectively and efficiently as possible. Kind of echoes what we saw from the Alabama judge. So for Lana Patrick, here was the state's rebuttal to the charges that she was convicted on. Then here was the prosecution said no unfettered right to, in the public area of a courthouse, filming whatever she wants. And then they cited to a case that the state, no less than a private owner of property, has power to preserve the property under its control for the use which is lawfully dedicated. This was the United States brief, described the crimes. The argument there is that, you know, does it cover videotaping? I would think that it would, because videotaping is a more pronounced version of photographing. And the signs did say both, but they'll let that decide that in the briefing. And here is where the prosecution is talking, by its very nature, this business involves the exchange and discussion of a large amount of sensitive personal identifiable information. It's a Social Security office. So to say that you could walk in and start aiming cameras at the monitors, aiming cameras at employees that are talking directly to someone that may be talking about their Social Security benefits, filming forms that they're filling out, I just don't see that happening. That's where the constitutional right of privacy is going to trump your First Amendment right. Here was the judge issuing his verdict in the DMA case, and there were 2 counts, convicted on both. Prohibiting inside the second set of interior doors. And then it says, although I respect his right to challenge the law and test his constitutional rights, he is wrong in this instance. It says, where a person might enter from outdoors directly into a federal office, the outcome could be different. Here, there was a distinct entryway from outdoors corresponding with a subsection C space, an area where you could film, after which a set of interior doors leading to a distinct, unmistakable office space corresponding to A and B. So that was the conviction. Then they showed the Jerry Stamps case here that was attached to the USA's brief. He's a YouTuber convicted on a single count. They gave him a $120 fine, went to trial, then said he would appeal it. That pissed the judge off. Suddenly the fine became $500. And the judge basically was saying, yeah, I'll deem you to be a news service as well. But in addition, the court, it would really be the auditor, filmed private individuals coming and going from the building. He filmed the security guard that worked behind the desk. And that included filming material the guard pulled out of his desk to work on or review. In addition, the defendants you can repeatedly see him filming individuals seeking services at office number 1, which was directly inside the door of the foyer area. So this is very consistent reasoning, what we had with DMA. You're filming too much. You're going beyond your right to just simply film as allowed in the CFR. You're intruding on rights of privacy. It says it's clear he was not there to film the entrance, the lobbies, or the foyer, which he was allowed to do, but he was there to film employees of the SSA in their interactions with individuals who are seeking services. This is not permitted under the rules, and the court finds the defendant did film areas of the Social Security office beyond what was permitted by the regulation, even if he were to qualify as someone who was filming for news purposes. His First Amendment claims are not valid in this case. There was no violation of the First Amendment telling him he couldn't come in to film the interactions between those seeking services and the employees of Social Security. This, to me, is basically, throwing down the gauntlet. It just says, hey, look, you know what? There are restrictions to these things. Here was the case that I found, Florida Star versus BJF, quote, a United States Supreme Court not found in George Metz's case, not found by the prosecution. Why do these guys and their legal abilities suck when it comes to legal research? I know of a case where they couldn't really find any Nevada case law on it that I found in minutes flat. Amazing, isn't it? Quote, we continue to believe that the sensitivity and significance of the interests presented in clashes between the First Amendment and privacy rights counsel rely on limited principles that sweep no more broadly than the appropriate context of the instant case. Where information is entrusted to the government, a less drastic means than punishing truthful publication almost always exists for guarding against the dissemination of private facts. Once the government has placed such information in the public domain, reliance must rest upon the judgment of those who decide what to do to publish or broadcast. And hopes for restitution must rest upon the willingness of the government to compensate victims for their loss of privacy and to protect them from other consequences of its mishandling of the information which these victims provided in confidence. So there you go. U.S. Supreme Court case involving the same state in Florida. They made it very clear. The U.S. Supreme Court has made a decision that you can place limits on the First Amendment when it comes to safeguarding private information. I mean, why would that be a question? So there you have it. Privacy, First Amendment. There are some offices that you really need to stay away from. Those government offices, in my book, are it. You're walking into a load of trouble. And as this case law gets more developed, so far all I'm seeing are convictions. And, like that judge in the Stamps case, federal judge, he's like, okay, I can't really find any law on this, or there's nobody's found any law for me. I'm going to use common sense. Would a guy with a camera be allowed to film what's the information that's on the screen between a government employee and the recipient of those services? Hell no. Government has to do something to protect that information. How they protect that information? Well, it's a question for another day. Hope you found this interesting, but that's really where we're at. It is a clash between the First Amendment and the constitutional right of privacy. And remember, the constitutional right of privacy is in several amendments. There's the Fifth Amendment, the right not to incriminate yourself. Okay. The right against an unreasonable search and seizure. You have that as right of privacy. This came about as well because of Roe v. Wade. So you don't find those words directly in the Constitution, but it was breathed into the Constitution as a form of liberty. I'll catch you on the next one.